attorneys, people who represented immigrants in the court process, involved in developing the new, what became known as the risk classification assessment tool. And what that automated tool does is bring together in an automated way, based on very complicated, certainly more complicated than I can totally understand, algorithms that attempt to balance the individual's immigration history, criminal history, and personal history in a way that makes sure, as I said earlier, we are detaining the people who need to be detained based on either flight risk or threat to the community or threat to national security, and not detaining the people who don't pose a flight risk or threat to the community or national security. And so when a person is brought into ICE custody, their fingerprints are taken, and those fingerprints generate into the automated system their immigration history, if there is one. Were they ever encountered before? Were they ordered removed? Were they released on some sort of a bond and then never showed up? Were they removed from the country before? Now they're back. So what was their immigration history? That is automatically loaded into the system based on fingerprints. Same holds true with their criminal history. If they've ever been arrested in the United States for a crime, if they've ever been convicted of a crime, if they've ever served a sentence for a conviction, all that information is automatically downloaded into the system. Then the officer conducts a personal interview with the person, and they ask questions such as, are there any health issues? If a female, is the female pregnant? Is she a nursing mother? Does the person have any history of mental illness? Are they taking medication for that mental illness? Are they married? Are they in a committed relationship of some sort? Do they have children? And this is very important because obviously we don't want to detain a caregiver and leave the children without any form of support. I'm not quite sure how this works in Israel, but in the United States, if someone who is not here lawfully has a child in the United States, that child is automatically a U.S. citizen. So it's very common to have someone who is subject to being deported because they're here unlawfully, but that person could have one or more United States citizens' children. Do they have any special vulnerabilities based on sexual preference and issues? Are they a transgender individual? Are they a victim of human trafficking? Are they a victim of torture? In some cases, in a number of cases in fact, they may be here at the moment lawfully. They may be a legal permanent resident, someone who has a green card but has been convicted of or charged with a crime that would then revoke their green card and make them deportable. So do they have a permanent residence? Do they own a home? Do they have a job? All of this sort of personal information is entered into the risk classification tool at this interview. And at that point, the computer, as I said, based on the algorithms that have been developed, will make recommendations. And I have to stress that these are recommendations for the officer to consider. The recommendations will be, first and foremost, should the person be detained? If they're going to be detained, what type of a detention center would be appropriate for them? As I said, they range from residential to maximum security. If in that detention center, does the person have access to the type of medical care they might need if they have medical issues or mental health issues? If the recommendation is not to detain the person, the system will then also recommend what type of supervision they should be placed on outside of a detention setting. Should they be placed on an ankle bracelet? Should they be given a bond? If the bond is appropriate, what dollar amount should they have to post in order to secure the bond. So all of these types of recommendations are made by the system, and the officer then has the opportunity to override those recommendations and do something differently. If the officer decides to override the recommendations, they have to document in writing into the system the specific reasons for overriding that recommendation, and that override, if you will, has to be approved by a supervisor. So all of this is very carefully documented. And in addition to having a complete record of what was done and why, this information helps us fine-tune the system. During the first year of operation, we found that officers were overriding recommendations from the system in about 25% of the cases. And they were typically overriding a recommendation to release someone who had a significant criminal history, or overriding a recommendation to detain someone who didn't have a criminal history. And using that information, the algorithms were adjusted, and today about 7% of the recommendations are overridden by the officer and approved by a supervisor. But overall, the system is working extremely well. It doesn't take particularly long to do. Once the officers become adept at following the computer-generated questions and using the drop-down boxes that give them standard inputs into the system, they can process someone within 20 to 45 minutes, which is about what time they used to take when they were doing it in a more manual way. So let me stop right there and see if there are any questions about the risk classification tool, and if there are, I'd be happy to answer them before I move on to alternatives to detention.
Are there any questions at this stage? No questions so far, so we can continue. Can we continue since there are no questions? Yeah? We'll move on and we'll take more questions at the end.
All right, very good. The other program that we are very proud of, in addition to the risk classification tool, is what we refer to as the Alternatives to Detention program. As I mentioned, we have on any given day about 25,000 people on a formal alternative to detention. And these alternatives range from ankle bracelets using GPS to track where they are, to voice recognition technology where people call in and the machine can read their voice pattern to make sure they are who they are and that they're calling from the appropriate place. It includes visits from staff people to make sure that they are at work or at home, and it involves the individual reporting to an office to just update their status and again make sure that they have not absconded. In its fullest form, this program also provides other services to make sure that the person is successful in the community, that they have access to health care, that they have access to religious support if they need that. For those people that are eligible to work, to make sure that they have the opportunity to find jobs, to make sure that their children are being cared for. So it is a full service program for many of the people. There are some 15,000 people of the 25,000 who are getting these complete services as part of the ATD program. The other 10,000 really are just being asked to comply with the conditions of supervision, such as calling in and having their voice recognized, but they're not getting the full services. The program is extraordinarily successful. well, in 99% of the cases, people on ATD show up for all of their immigration hearings. That number drops off somewhat when it comes time to leaving the country, when they're ordered to go home, assuming that's the outcome. Then about 85% of the people on ATD comply, and about 15% abscond or don't comply in some other way. In that 15%, in addition to people who abscond rather than leave, we also have people who might be arrested for some other criminal act and get taken off the program. We have people who just fail to comply and may be taken off the program and put into a detention facility. So overall, very successful. At least 85% have total compliance up to and including leaving the country when so ordered. So we're very pleased with that. And one of the ways that we've continued to improve that program over time is to understand that the risk of flight and that the risk of compliance changes during the immigration process. Someone who is going through the process of attending hearings and having their cases heard are generally pretty likely to comply, and so you don't need as much supervision of them in the community. As they get closer to the end of their immigration case, particularly if it looks like they're not going to be successful and allowed to stay, the risk of flight increases, and at that point we would sort of ratchet up, if you will, the level of supervision and apply, an ankle bracelet, more frequent visits, and so on to mitigate the increased risk of flight. But it does work, as I said, it is working very well, and it is potentially a much cheaper program than detention. As I said, we spend $1.5 billion a year on detention facilities. The average cost is about $122 a day per detainee. This full service alternative to detention could be as little as about $14 a day. So a much more cost-effective way of ensuring compliance and mitigating the risk that someone will abscond rather than be removed. Then there's another program that we started about a year and a half ago, that I think has really great potential, and that is our community supervision and community release program. Two faith-based organizations, the first was the Lutheran Immigration Refugee Services, and then shortly thereafter the Catholic Charities, have started programs where we release to them certain low-risk individuals, people who don't have any criminal history, people who we think have ties to the community. We release them to these two faith-based organizations, and they are responsible for making sure that they can be successful in the communities and doing what they can to help make sure that people understand that they have to comply with the immigration process. So far, I think we have about 200, maybe somewhat higher than that, 200 participants in these two programs, the Lutheran and the Catholic program, and we are optimistic that this will be yet another way to supervise people outside of the formal detention process. The difficulty with that program is that currently the federal government, U.S. government, does not have any means of compensating these faith-based organizations for their efforts, and so the Lutherans and the Catholics have to pay for this program themselves. There has been conversation, within ICE and with the faith-based organizations about ways to try and find compensation sources so that they could expand these programs, but that has not happened yet, and there isn't a specific plan yet to try and help pay for the program. But again, very promising for a number of reasons, and hopefully it will continue, and funding will be made available at some point in the future. The last thing that I was asked to mention today is different types of people, different types of groups of people who are allowed to stay in the United States even though they would otherwise be deportable. And there are really three types of people who fall into that category. The first one is people who come, let's say, across the southwest border of the United States unlawfully and present an asylum claim, that they have a fear of being sent back to their country, that if they are sent back, it would result in torture, possibly, or even their death. Those claims are adjudicated, and if the person's fear is determined to be substantiated, they are granted asylum and allowed to stay in the United States. That is a very difficult claim for an individual to make and have sustained, because the U.S. immigration laws demand, if you will, that the threat of torture or persecution is to some extent specific to that person. And the best example I could give is that, if there is crime in that person's hometown, in their home country, that crime and the prevalence of crime may not be enough to sustain an asylum claim unless they can show that they, as an individual, are particularly vulnerable. For example, they testified against a gang member or a gang, and as a result of that testimony, they, as an individual, are under a higher risk of bodily harm. That's the sort of claim that has to be substantiated in order to be successful, generally speaking. So we've got people seeking asylum. We also have what's called temporary protected status. If people from a country where there has been a natural disaster or some sort of dramatic civil unrest, other circumstances that are significant to the country, the Department of Homeland Security can grant people from that country what's called temporary protective status. They can come into the United States and stay here as long as those conditions exist back in their country, and they are eligible to work. They're eligible to move freely about the country. They are not detained in any way, and they are, as the term indicates, they are here in a temporary protective status. Now, in theory, when the conditions back home are resolved, they are supposed to go home. I can tell you from experience that doesn't happen very often. And so people who come here on TPS, as the people refer to it, tend to stay here, indefinitely. Then the last group of people who are here, even though they are eligible to be deported, are people from what we refer to as recalcitrant countries. And those are countries where they either refuse to take their citizens back, or they make it extremely difficult for the U.S. to send them back. For example, Vietnam, certain people before the current regime in Vietnam was established, they are extremely reluctant and almost never take those people back if they came to the United States before the new regime was established. China is extremely difficult to return people. India is very difficult to return people. For example, there are probably 40,000 Chinese nationals at large in the United States who were ordered removed by an immigration judge for whom the U.S. cannot get permission from China to send them back. So we have those sorts of people as well. So those are the three categories of people who are here, people who are seek and are granted asylum, people who have temporary protective status, and people who have been ordered removed and would be removed but for their country of origin either refusing to take them back or making it extremely difficult to send them back. So let me stop there. Those are the three topics that I wanted to talk about, and I'd be happy to answer any questions about them or any other part of the U.S. immigration process.
Any question? Please come over here so we can see you and hear you.
Well. What is the legal status, for example, of those 40,000 Chinese who cannot be sent back?
They are they are absolutely in limbo. There is no path for them to become even what we refer to as green card holders. Technically, they are not permitted to work. They are people who are, as I said, in a complete limbo status. And many of them have been here for many, many years and no prospects of returning back to China and no prospects of ever becoming U.S. citizens. And there's actually something that causes members of the United States Congress concern from time to time, and that is the fact that the U.S. immigration authorities only have the right to detain someone for the purposes of deporting them. So we can only put in detention